Honorable D.F. Forrester, Attorney General of Grenada, Honorable Delma Thomas, Minister in the Ministry of Social Development, Housing and Community Empowerment, Mr. Alois Kamuraji, Representative, UNICEF Office for the Eastern Caribbean Area, Heather Stewart, UNICEF Barbados, Elaine Henry McQueen, Program Coordinator for the Grenada Spotlight Initiative to End Violence Against Women and Girls, Ms. Shirlene Herbert, President of the Grenada National Organization of Women, Mr. Dashan Ramdani, Grenada's Spotlight Legal Advisor, facilitators, specially invited guests, participants, persons joining us virtually, members of the media, friends, welcome all to the workshop on law reform for preventing violence against women and girls in Grenada, Carriacou, and Petite Martinique. We are going to start our opening ceremony this morning by inviting the presence of the Lord, and I am going to ask Ms. Giselle Samuel to join me at the podium for a word of prayer.
Good morning, all. I invite everybody to get in the manner of prayer. Heavenly Father, we thank you for this opportunity today to stop, reflect, and think about the violence against our women and children. We pray that as we gather here today, the various objectives in which we have set forward will be met. We humbly ask that you create in our hearts love, compassion, and mercy so that we may become agents of justice and peace. We pray this in Christ our Father. Amen.
I'm going to ask you to remain standing, please, as we enjoy some sweet steel pan music, the national anthem of Grenada by Josanne Drakes. Thank you, Josanne. You may be seated. At this time, I'll invite to the podium, yes, round of applause. Thank you, Josanne. At this point, I'll invite to the podium Ms. Shirlene Herbert, President of the Grenada National Organization of Women, to make some welcome remarks.
Honorable D.F. Forrester, Attorney General, Honorable Delma Thomas, Minister, Ministry of Social Development, Housing and Community Empowerment. Heather Stewart, UNICEF Barbados. Elaine Henry McQueen, Program Coordinator, Grenada Spotlight Initiative to End Violence Against Women and Girls. Mr. Darshan Ramdani, Grenada Spotlight Legal Advisor. Executive members of GNOW, facilitators, specially invited guests, participants, persons joining virtually, members of the media. Good morning. It is indeed my distinct pleasure on behalf of Grenada National Organization of Women to say a hearty welcome to every one of you gathered here today for this sensitization workshop on law reform as it relates to violence against women and girls. Today we will review some of the existing laws with the experts in the field, identify gaps, look at law reform and policy with a view to how we move forward and influence the change that needs to be done. We particularly welcome the representative from UNICEF, Ms. Heather Stewart. We welcome the opportunity to participate in this Spotlight project. As we continue to deal with what is considered a new pandemic of domestic violence and abuse, we must do all that is necessary with the available resources to continue the movement towards eradication of gender-based violence, violence against women and girls. This we truly believe is achievable. We agree there must be behavioral change and empowerment. Everyone needs to be on board, speaking the same language. Say no to violence. The fact that we have embraced this opportunity to show up today is testimony we are serious that the status quo needs to change. Let us participate fully so that going forward we'll be better poised to chart a new course, take action, and reduce the alarming statistics and influence the change. I quote the old African proverb, if you want to get there fast, go alone. If you want to go far, go together. We are here together on that journey. So with this type of engagement, the discourse becomes inclusive. Let us not leave anyone behind. Welcome again, everyone, and let us treat everyone we interact with today with dignity and respect. Do have a productive day. Thank you.
Thank you, Ms. Herbert, for setting the tone for today's proceedings. I'll now invite to the podium Ms. Heather Stewart, who will deliver some remarks from UNICEF on behalf of Mr. Alois Kamuraji, the representative for the UNICEF Office for the Eastern Caribbean area. Ms. Heather Stewart.
Thank you, Ms. Chairperson, Jasmine Redhead. I don't think we quite announced you. Honorable Dia Forrester, Honorable Attorney General, and I must pause here to say that the Attorney General has been leading this charge for law reform in a very personal and direct way. UNICEF thanks you. Honorable Delma Thomas, Minister, Ministry of Social Development, Housing and Community Empowerment. While she's not physically with us, we know that she's online. And Minister Thomas herself, her ministry, leads the entire Spotlight program, and she too has been very personable in this fight. Mrs. Elaine Henry McQueen, Program Coordinator of the Grenada Spotlight Initiative to End Violence Against Women and Girls. Elaine is under the weather today and therefore not with us. Mrs. Shirlene Herbert, President of Grenada National Organization of Women. We take this opportunity to say thank you so much for joining with us. Mr. Darshan Ramdani, Grenada Spotlight Legal Advisor, will also be joining us virtually, and you'll see him a little later. Facilitators, we owe you a debt of gratitude. Specially invited guests, participants, persons joining virtually, members of the media. I am Heather Stewart, Child Protection Specialist with the UNICEF Office for the Eastern Caribbean area. And yes, our main office is based in Barbados, and we cover Grenada from there. And I bring greetings from Dr. Alois Kamaragi, our head of office, who is unavoidably absent from Grenada today, but I assure you that his heart is right here. Violence against women and girls is a silent pandemic the world over, but it is one that we can only treat by working together. That is why we are so proud of the joint efforts of government, UNICEF, and our sister UN agencies, and the European Union in this Spotlight initiative. This initiative is the world's largest targeted effort to end all forms of violence against women and girls. It is working to improve legislation and its implementation. It is working to change the harmful social and gender norms that underpin violence. And it is improving access to and the quality of essential services for survivors of violence. UNICEF truly applauds today's partnership, which is spearheaded by GNOW. Together with the Attorney General's Chambers and the Ministry of Social Development, GNOW has brought together state agencies, national and community organizations, and media partners to raise awareness on the further law reform efforts that are required. Grenada is not an empty slate. Significant legislation is in place. But like all great efforts, the 2021 Comprehensive Analysis of the Laws Governing Violence Against Women and Girls, completed under the Spotlight Initiative, shows that even better can be done. UNICEF hopes that these further inputs will help to prevent violence in the first place, increase the reporting of any incidents, and provide girls and women with faster and more effective support. These efforts work hand in hand with other initiatives under the Spotlight program. Already, the Spotlight initiative in Grenada has led to progressive new draft legislation and policies, which we will discuss today. Training modules, operating procedures, improved data gathering, improvement in services, empowerment of civil society organizations, and increased public sensitization. So we are on our way. The Spotlight initiative is proof that when governments, UN agencies, and civil society work together, we can make a difference. Together, our commitment has never been more necessary. Over the past 2 years, the COVID-19 pandemic has disrupted or closed key services, including in health facilities and schools. Meanwhile, economic pressures in many countries are increasing the risk of violence. The Spotlight initiative shows up the continued need for investment to prevent violence and to provide effective responses. Today's consultation is testimony of your interest in this investment. The social change legislation that we will address may be uncomfortable in some parts, but discuss we must. Violence against girls and women is preventable, and change is possible. Like GNOW's president, I echo, let us continue to lead this change together. UNICEF thanks you.
Thank you, Heather Stewart. And let me just remedy the situation. I will formally introduce myself. My name is Jasmine Redhead, and I am the in-house counsel at the Legal Aid and Counseling Clinic. At this time, I will introduce Honorable Dia Forrester, our Attorney General, and she will deliver the feature address this morning. Ms. Dia.
Good morning, everyone. I adopt the protocol that was established. Too many women have the same stories. Too many girls now and in the future may have those same stories. It continues to be more likely than not that as a woman and/or as a girl, you are likely to encounter some form of violence in your lifetime. The extent of that violence may vary, but it is still violence. On a contemplation of what is violence, it is apparent that there is no legal definition for it and/or generally accepted definition of violence. Violence is more a concept associated with physical force, but it may be verbal, it may be psychological or emotional, as it may take many forms. It is useful to think of violence as any form of treatment or procedure that may injure you, be abusive, cause damage or destruction. The World Report on Violence and Health from the World Health Organization defines violence as the intentional use of physical force or power, threatened or actual, against oneself, another person, or against a group or community that either results in or has a high likelihood of resulting in injury, death, psychological harm, maldevelopment, or deprivation. How do we tackle this concept of violence from a legislative perspective? Or put differently, how do we prevent and respond to violence against women and girls from a legislative perspective, particularly in a manner that will transform the lives of women, girls, and families in Grenada? The Office of the Attorney General and the Ministry of Legal Affairs have been tasked with this undertaking in Pillar 1 of the Spotlight Initiative in Grenada, themed legislation and policy frameworks. It is part of the Spotlight Initiative program and pillar, Laws and Policies, which seeks to promote laws and policies to prevent violence, discrimination, and address impunity by advocating at all levels of government, providing technical assistance and capacity building, ensuring active and meaningful participation of women. Today, I will examine the importance of law reform under the Spotlight program to transforming the lives of women, girls, and families in Grenada. In examining the importance of law reform, it is necessary to consider the role of the law in tackling that fundamental issue of violence against women and girls. The law reform taking place in this Spotlight initiative is centered on promoting the rule of law, as the reforms under consideration touch on broad components of the judiciary, law enforcement, and human rights. Let me narrow in for a moment on what we refer to as the rule of law. The rule of law is what informs the process of reviewing and vetting and modernizing our legislation and regulations in our law reform process. There is much learning on what is the rule of law. Lord Bingham gave 8 principles that he describes as being the rule of law, 3 of which touches on key things one would like to highlight. The law must be accessible, so far as possible, intelligible, clear, and predictable. The law must apply equally to everyone unless differences can be justified. The law must provide appropriate protection of essential basic human rights. Beyond the broad principles of what is the rule of law, when one thinks of the rule of law in the context of law reform, it is important to recognize that law needs to be reformed to adapt to societal changes while adhering to constitutional norms and principles. That requires a determination of what societal changes are needed, and then the introduction of those changes, which is really a technical consideration of problems and was once the extent of the law reform process. Time has shown that the focus of law reform cannot solely be a technical consideration of problems. The focus must be on enhancing capacity and changing behavior. We need the rule of law to enhance our law's capacity to actually guide human conduct, to create an enabling environment that significantly reduces violence against women and girls. In Grenada's Spotlight Initiative, there are 6 categories of law reform under consideration based on the findings of the legal gap analysis. Those 6 categories are sexual offenses reform, domestic violence reform, child protection reform, victim protection reform, family law reform, and institutional law reform. The legal gap analysis that informs the 6 categories of law reform was published in June 2021. That legal gap analysis was the technical investigation of the laws as written, also referred to as a desk review. Policy papers and draft pieces of legislation on the 6 categories have been developed and sets the framework on how we propose to deal with the needed reforms from a technical perspective. To determine the adequacy of what was formulated or what should be formulated requires extensive discussions and consultation with various stakeholders and representatives of various interest groups. The inputs and recommendations coming from the discussions and consultation is salient to capturing the true context of Grenada, Carriacou, and Petite Martinique, and ensuring that the measures being proposed as law reform are achieving the objectives or the purpose of the endeavor, so that it creates an enabling environment that significantly reduces violence against women and girls. To achieve that environment, the policy decisions proposed for reform must be based on our local context. So though violence against women and girls is a global issue, our reforms must be contextual. That is, it must relate to the society of Grenada, Carriacou, and Petite Martinique. Consultation and consideration are the mechanisms to ensure that policy development and primary legislation contains all the material which it ought to contain in order to achieve its intended purpose in our country. There must be a detailed examination and consideration of any law reform proposal. So your task is to scrutinize what you have been presented. I encourage you to share your most critical, subjective, and objective considerations. Also, make innovative and progressive recommendations, because that is the only way they can be a work product which, when implemented, achieves its purpose. When our law reform process is of such a nature, we are then able to take ownership of it. Taking ownership of it means that we have reforms that we are able to implement, that we are able to enforce, and that sector of society we have targeted can access and benefit from what was done. That ownership is also based on a mandate for education, legal education too, as these are the things that will influence the cultural and social change that must accompany law reform. There is no fact-checking or authenticating of the accounts and recollections of participants in consultation and discussions, nor is such a process necessary. Recognition of personal recollection and experience of valid sources to help us understand where our country is at, because you are all experts in the experiences that you share. Your accounts will generate the narrative to delegitimate existing laws that are either preserving discrimination, it will bring to the forefront matters that are not yet accounted for, and justify the needed reforms, which is a key role in that process of law reform. As you engage in the consultation and consideration of the policy and legislative initiatives, it will be useful for you to have these factual realities of Grenada, Carriacou, and Petit Martinique in mind. Firstly, domestic violence, intimate partner violence, and sexual violence are amongst the biggest challenges facing women and girls in our tri-island state, and those stem directly from the institution of the family. We are unfortunately amongst countries with the highest global earliest age of sexual debut, as that starts prior to the age of 13. The issue is compounded by complicity, silence, denial, and failure to take appropriate action. Common law spouses have little to no benefits as a matter of law and have limited legal recognition despite the prevalence of that family construct. Likewise, the children of those types of relationships have no protection under the law. For example, there are no provisions for spousal support, division of property acquired during such relationships, rights on death of one partner. There is no presumption of paternity in relation to children born out of wedlock. This position tends to put many women and children in a disadvantageous position because of the silence of the laws. Those are some of the issues that show the disparity in gender-related issues. There is need for more focus to be placed on gender sensitivity and individuals being adequately trained to be gender sensitive. Gender-based inequalities driven by gender stereotypical norms and expectations are curtailing the development of our women and girls, limiting their access to resources that can empower them in different ways. Law reform must capture how we encourage these vulnerable groups to engage with the laws, which laws should improve their experiences in life, whilst at the same time treating with those who may be offenders. It is important here to state that there is a difference between enacting new legislation and effectively enforcing legislation. Getting the rules and concepts into law, for example, introducing new legislation defining offenses or governance procedures, does not take us over the hurdle of the effective implementation of legislation. Black letter law, that is the rules and principles, the progressive concepts and approach to the law and the ideals that black letter law captures in writing, can only turn into tangible returns beneficial to women and girls if we take a wide approach to law reform. That is a significant strength of the Spotlight Initiative and the approach being taken in Pillar 1. There are non-legislative recommendations and extra-legal measures in this law reform process that will impact the effective enforcement of what will be the legislative reforms. For example, proposals for the introduction of a family court, which is a major complement to reforms relating to access to the court, the rights of children, dealing with family-related issues outside of the civil courts, but in an environment that is created specifically to appreciate the sensitive nature of family issues. There are always high expectations of a speedy change coming from law reform, and reasonably so, as these are urgent matters. Yet, none must be under the illusion that law offers an easy solution to the problems we are grappling with, the real-life needs of our women and girls as most vulnerable groups. There has to be agitation and activism to get these reforms off the ground and into laws, and into the cultural and social changes in thought processes that transform what are societal norms and what is acceptable and what will not be tolerated. One cannot stress sufficiently that we must be relentless in ensuring that we move the work product, the proposed reforms which will be modified and enhanced by the discussions and consultations undertaken today, from being this amazing raw material into tangible returns where we see, in this country, the reduction and eventual elimination of violence against women and girls. Though the government of Grenada, whom is tasked with policy development and law reform, has not yet been engaged to approve any of the proposed reforms in Pillar 1 thus far in the Spotlight Initiative, that is the next step in the process. An executive's ability to accept proposed law reforms and a legislator's ability to debate and pass proposed law reforms is always made easier if the inputs in the formulation of what is being proposed is done well. I commend all who are leading and participating in the Spotlight Initiative, and in particular, Pillar 1 of the Spotlight Initiative. The time is right to pursue these matters. Thank you.
Thank you, Honorable Attorney General, for affirming your commitment to the law reform process as it relates to preventing violence against women and girls, and importantly, making that linkage between us as stakeholders and the policy and lawmakers. I will check in with our technical team. I know we were experiencing some difficulties earlier on. We will now invite virtually some ministerial remarks on behalf of the Minister of the Ministry of Social Development, Housing and Community Empowerment, Honorable Delma Thomas, and I believe Ms. Chrissy Worm will be giving those remarks on her behalf. Thank you.
Thank you very much, Madam Chair. Pleasant good morning to Honorable Dia Forrester, Attorney General, Dr. Aloys, hopefully he's online, and Ms. Heather Stewart from UNICEF Office for the Eastern Caribbean, Ms. Shirlene Herbert, President of Grenada National Organization of Women, Ms. Elaine Henry McQueen, I understand she's not here, but I'm not sure she's online, but good morning to you, and Mr. Darshan Ramdani, Grenada Spotlight Legal Advisor. Ladies and gentlemen, all invited guests, members of the media, good morning all. I bring you greetings on behalf of our Minister, Honorable Delma Thomas, Minister for Social Development, Housing and Community Empowerment, who's unable to make it today. But nonetheless, our heart is right here, and I'm going to start. Social justice means loving people so much that we work to change structures that violate their dignity and sparing no efforts to building a peaceful society. And on that note, we thank so much UN system and the European Union, who would have invested so much in our country and continue to join us as we work together trying to end violence against our women and girls. The lived realities of our people on their journeys should be experiences of empowerment and fulfillment. Hence the need to embrace the complexities we face and examine the various and multiple dimensions with solution and strengths-based approaches. Therefore, it is the trust of the government of Grenada to continuously build on systems cemented within a rights-based perspective that inherently embodies the human worth, dignity, social justice, and leaving no one behind principles. And so today's activity is one step closer into recognizing and supporting meaningful legislative reforms that reinforce social justice, social protection, and national sustainable development. It further reemphasizes the need for continuous engagement that creates change and supportive mechanisms towards a more resilient, peaceful Grenada in this new era. It prioritizes the need to use a social justice lens in our reflection on current challenges facing the lives of our citizens and examine ways to advocate for needed changes. Some of the reforms that will be highlighted today were developed as a result of careful analysis, extensive engagements underscored by the challenges, experiences by many of our people. It demands that we continue to work together to build systems and practices that strongly articulate a commitment to social justice. We hold firm to our belief and remind ourselves that solutions to our challenges will emerge from dialogues that embrace diverse perspectives. The government continues to be committed to being the vanguard of the vulnerable and have taken and will continue to take actions in this regard. And so I am very happy to be a part of this forum, bringing greetings from our minister, that will provide a framework for strengthening the way in which we educate for justice and prepare social practitioners for competent and ethical practices dedicated to both service and justice so that our vulnerable population's right will be further realized. So I thank you very much, and I want to say best wishes for a successful meeting, and I'm looking forward to the changes that is going to be created as we all join forces together. And I think that was a common thread throughout today's initial meeting. Join together, ending violence against women and girls. Thank you very much, and over to you, Madam Chair.
Thank you, Permanent Secretary in the Ministry of Social Development, Housing and Community Empowerment, for the words of encouragement and support. At this juncture, I'll invite Ms. Narina Brown, member of the Grenada National Organization of Women, and she'll deliver the vote of thanks.
Good morning, everyone. Thank you, Madam Chair. On behalf of GNOW, we would like to extend our heartfelt gratitude to UNICEF for their continuous support, also the Attorney General for giving the feature address, Madam Chairperson for chairing this morning's session, all the facilitators that will be hosting sessions throughout the day, the participants for taking time out of your busy schedules to attend this session, also the media for broadcasting this event, and to everyone joining us virtually, we'd like to just say thank you, thank you, thank you, thank you.
Well, I must say I feel properly thanked. And we are going to, as the young people say, no sticking. We are going to move right into the next segment. We'll just allow the Attorney General. We know she has a very busy schedule, and we thank her for joining us here today. And we'll give her a few moments to allow her to get back to the nation's work. So I can give you an idea of what you can look forward to this afternoon. We are thank you. So today, we are tasked with the responsibility of critically, honestly, and of course interactively examining the state of our current laws as they relate to eradicating any form of violence against women and girls. In other words, we are going to ask ourselves, what are we doing well? What do we need to work on? And what have we not yet considered? In order to do this successfully and in order for us to have a meaningful conversation, we have lined up today an incredible group of presenters and facilitators. Now, I know all of them personally, and they are too humble to tell you this, but I, as moderator, I can safely say they are the best of the best. Collectively, they represent over 100 years of experience and expertise in this particular area. Now, the format we are going to follow today, to kick off our presentation, we'll have the legal advisor for the Grenada Spotlight Initiative, and he will give us an overview of the legal analysis and identification of key issues relating to violence against women and girls in Grenada. After which, we'll have an opportunity to ask some questions, and this will be immediately followed by a panel discussion on key policy and legislative issues for transforming lives of women and girls in Grenada. Again, we'll have an opportunity to ask some questions. Then we'll stop for lunch. I mean, we should have enough food for thought then, but we'll still stop for lunch. And this afternoon, you are going to get to do some serious work and brainstorming. And this is where we'll call on your experiences, your own expertise, your views on the matter. Now, everybody should have received a folder when they entered this morning. In the folder, you have a number of documents where you have your name tag. So I see most of you have your name tag. You're expected to write your name on it and clip it on. You also have a questionnaire. During the break, you'll have an opportunity to complete the questionnaire. Also, if you do not have a questionnaire, then we'll make arrangements to ensure one gets to you. There is also a small slip of paper. You have to be careful because it's clipped on, I believe, to one of the pamphlets, and it has a group number on it and a title of a group. This afternoon, we will break out into 4 different groups. Each group is tasked with covering a specific area facilitated by legal experts, and your small card will tell you which group you are assigned to. In the group sessions, we expect you to zero in on some of the key issues highlighted in this morning's session. We will ask you to think through some of the hard questions in a rigorous and principled way, and then report back to the plenary session later on. So let's jump right in. Without further ado, let me check with our technical team to ensure Mr. Ramdani is ready. So I want to introduce our first presenter, Mr. Darshan Ramdani, Queen's Counsel. As I said earlier, he's the Grenada Spotlight Legal Advisor. I personally describe him as a legal encyclopedia, but just to highlight some of his many accomplishments in the field of law. Mr. Ramdani, Queen's Counsel, is a former Attorney General of Grenada. He was also Solicitor General and Acting Director of Public Prosecutions. He has significant experience as a trainer, lecturer, and consultant for organizations such as the Organization of American States, Inter-American Development Bank, and of course, the Grenada Spotlight Initiative. He's the author of the criminal procedure textbook, Confession Evidence, Practice and Procedure for the Commonwealth Caribbean. Mr. Ramdani has sat as High Court Judge for the Organization of Eastern Caribbean States, Supreme Court. He has done stints in St. Kitts and Nevis, St. Lucia, the British Virgin Islands, Aguila, and Antigua. He has represented the government in constitutional and public law matters and was specially retained by the government of Guyana in certain high-profile criminal cases. So Mr. Ramdani undoubtedly has a wide range of legal expertise, which includes, but is not limited to, commercial law, constitutional and public law, trial advocacy in both civil and criminal areas. So without further ado, Mr. Darshan Ramdani, Queen's Counsel.
Thank you very much, Ms. Bedhead. Okay, I just want to share my screen. Okay. Right, and good morning again to everyone. I'm very pleased to join this process. It has been something that started with me when I was the Attorney General of Grenada, and I can see that we have done, in fact, quite a bit of work so far. This sensitization workshop is very timely and critical for us to continue this work. I have prepared a few slides for my overview of the work that has been done in relation to law reform. That is pillar one. To some context have already been given to you from the various presenters. I will add to that context, if only to frame my own overview and to indicate the work that we have done. You would have received a number of documents, and I believe your main organizations that you are representing today would have received some 18 plus draft legislation, but we'll come to that shortly. As you, some of you will be quite familiar with, violence against women and girls, including sexual violence, is prevalent in Grenada. The AG spoke about this. We are one of those countries that has not been missed, and throughout the wider Caribbean. As the Spotlight program for Grenada emphasized, domestic violence represents the highest incidence of gender-based violence, particularly intimate partner violence and sexual violence on the island. Indeed, intimate partner violence is the most significant and common danger to women in the region's Spotlight initiative to eliminate violence against women and girls. The prevalence of gender-based violence is corroborated in a 2018 study on Grenada, which notes 1 in every 4 Grenadian women has suffered physical violence at some point in their life. Close to 1 in every 10 Grenadian women has experienced sexual violence over her lifetime. The Attorney General spoke about this in saying that this is a story that many will have and many will come to have. Yes, besides violence, that is physical violence, women and girls are also adversely affected in several areas of life by unfavorable sex and/or gender-based inequalities driven by gender stereotypical norms and expectations. You would know, those of you who apply, have children or have family that have children, or persons with who are single mothers, if you go and you apply for a passport for your child or you attempt to travel, you have to have a father sign that document to get that passport or to allow you to travel with the child. And if it was the other way around, there is no need for a mother to sign and give consent in the current position that we have. Some countries, of course, have moved on from this, but this is not physical violence, but these are the kind of inequalities, the discrimination that affect our society even today. Now, law reform on its own is not the panacea for which gender-based violence will be remedied. It's not the solution or the sole solution. It is indisputable that the law is a powerful tool in the struggle to end gender-based violence and family-related violence. Law not only offers the framework that facilitates accountability and protection for actual or potential victims of said forms of violence, but it can also determine and influence cultural, social, and gender factors. Therefore, as the AG has pointed out, the law is well positioned to send the strong and unequivocal message that gender-based violence in all of its manifestations will not be tolerated, and violence against women and children is taken seriously by the state. And we are in that place right now where this is very obvious, at the commitment given by the state and all of the stakeholders and our civil partners. In that regard, the passage and implementation of laws that effectively address these forms of violence are integral parts of the state's responsibility to safeguard the security and personal integrity of women, children, and their families. Now, some of you may have sat through consultations in the past with myself on these matters, and so you will hear me carrying a similar message, but there's just so many ways that one can deliver the message that we are delivering today, that we are doing important work. We have been tasked with examining the laws of Grenada, and we are examining these laws against the backdrop of international standards and international best practices, of what is morally right, of what are the right things to do. And these are the things that we will want you to speak about as part of this interactive process. So as consultant on this project, I was tasked with examining our local legislation and putting it against that backdrop of international best practices and fundamental human rights as they are understood today. And so we have looked at a number of international documents. As you can see, let me take, sorry, I just moved it very quickly. Just one second. So our examination led us to work in pillar number 1, which is the legislative and policy frameworks of the Spotlight Initiative. You can see that the Spotlight Initiative encompasses 6 areas, and they are there on your screen: strengthening institutions, prevention and social norms, delivery of high-quality essential services, data availability and capacities, and supporting women movements. And these are the pillars that the Spotlight Initiative will cover in its work in Grenada and throughout the Caribbean. In looking at the work that we did, we examined a number of international instruments that set out these fundamental or the rights-based approach that we have taken. And you can see that they are there: the Convention on the Elimination of All Forms of Discrimination Against Women, ratified in 1990, the Convention on the Rights of the Child, ratified by Grenada in 1990, the CRC Optional Protocol on the Sale of Children, Child Prostitution, and Child Pornography, ratified in 2012, International Covenant on Civil and Political Rights, 1996, ratified in 1966, ratified in 1991, the International Covenant on Economic, Social, and Cultural Rights, 1966, ratified in 1991, the Inter-American Convention on Human Rights, and the Inter-American Convention on the Prevention, Punishment, Eradication of Violence Against Women. Now, these are all instruments that have set out what the international community, countries coming together, have recognized to be those fundamental positions, those fundamental rights that must be respected. For instance, the Convention on the Elimination of All Forms of Discrimination Against Women. This convention is the most comprehensive international legal instrument on the human rights of women and implicitly include girls under the ambit of its protection. The convention goes beyond the traditional scope of formal equality, pioneering the concept of substantive equality. CEDAW requires a transformation of gender relations within states, communities, institutions to achieve equity. We've also looked at the United Nations Convention on the Rights of the Child. This convention guarantees to every child, including girls, the rights, among others, to protection against sexual and other forms of abuse, the highest attainable standard of health, freedom from physical and mental violence, including from those from corporal punishment.
Mr. Ramdani, I'm sorry to interrupt you briefly, Queen's Counsel, but most of the participants here, like me, wear glasses, and we are having difficulty seeing the screen. So I'm just going to ask if you can do the slideshow so that it will be a full screen.
All right.
Excellent. Perfect. Thank you.
Sorry about that. Yes. I had assumed somewhere in the back of my mind that we were going to have a large screen up. Let me see how I can move this around. Okay. Okay. Thank you. All right. So can you see the screen now?
Yes.
Right. I was covering some of the
Perfect.
material. Yes. Right. Good. So we were I think speaking on the last slide a few seconds ago, which was the United Nations Convention on the Rights of the Child, CRC. This convention guarantees to every child, including girls, the rights, among others, to the protection against sexual and other forms of abuse, the highest attainable standard of health, freedom from physical and mental violence, including from corporal punishment, a compulsory good quality education, and the United Nations International Covenant on Civil and Political Rights. We've also examined those, which guarantees to all people, among others, equality before the law, equal protection of the law without discrimination. And this concept of discrimination has been spoken about earlier, and it is one of those prevailing concepts that we always have to be continuously aware of. 3, legal prohibition of discrimination on arbitrary grounds such as sex, legal protections against discrimination. It specifically commits states to effecting measures for the equal right of men and women to the enjoyment of all civil and political rights. It also contemplates effecting measures for the protection of children. And so you heard the AG this morning speaking of the rule of law, and you heard, I believe, the Permanent Secretary on behalf of the Minister speak of a rights-based approach. And this is the context, because many of us would be aware well, some of us may be aware, I hope all of us, of what are those fundamental standards that we must aspire to. And sometimes our own personal beliefs are aligned with those fundamental best practices and what is considered a rights-based approach. The task and the challenge for us is to be able to recognize the difference when our own beliefs are slightly varying from what is supposed to be the right thing to do. And an understanding of these international standards, understanding of the rule of law, and an understanding of a rights-based approach helps us to determine what should be the course that our country laws should follow. And this is going to be part of the task that you will be put to today, looking at your own beliefs and comparing them with what are the best practices. So these are the principles which guide the work on the Pillar 1 of the Spotlight Initiative. As the AG indicated, a gaps analysis was conducted. The laws of Grenada were examined and placed against the tapestry of this right-based approach. And so we found that there was of course work done in Grenada in the past. There has been work done on that Domestic Violence Act that presently governs the domestic violence application and protection for victims of domestic violence, that was passed in 2010. The Child Protection and Adoption Act that same year. Some amendments to the Criminal Code, some significant amendments rather, were passed in 2012. And there was also some amendments to the Education Act in 2012. So we did see that there was work being done. There is, but what we saw was in our analysis that there was considerable work to be done. Put it mildly, there's considerable work to be done, and we have listed them under 6 headings, as it were. The AG adverted to this as well. We have said that those those gaps that we have seen in our laws, missing, well, things that are not there in our laws, or some of those things that are actually in our laws, lead us to believe that these areas must be tackled. Child protection law reform. Some work needs to be done here. We've also seen that some work needs to be done in sex offenses law reform, domestic violence law reform, family law reform, victim rights law reform, institutional law reform. That relates to a family code. Now let me say this. You have been passed a number of legislative documents, meaning bills. We have taken the initiative of drafting some laws. These are, of course, not at all at the stage of approval. They are not at all representing any policy position of the government. These are simply the work done by myself in terms of what I have seen in my examination of the law, and I've seen, comparing it with what is considered to be the best practice, what needs to be done. How far we go, whether those documents stand up to the scrutiny of this consultation process and other such processes, time will tell. So in relation to child protection law reform, our gaps has shown, the gaps analysis has shown that Chapter 180 discriminates against children born out of wedlock, referred to as in the Act as illegitimate, in respect of maintenance orders, in that there is no presumption of paternity. This presumption applies to children born into wedlock. That same act prohibits the court from making maintenance orders in respect of spouses who have committed adultery. The establishment of a minimum rate of maintenance set for spouses to $25 a week, for children $15, sets a low threshold for the costs associated with providing children. No such threshold is set for child maintenance in the High Court, and enforcement mechanisms are not adequately addressed. What this is really saying is that, look, when you turn up in the magistrate's court, there's quite a bit of barriers in our own legislation to prevent children who are born out of wedlock from having maintenance being given to them. And in fact, the rates are so low that it hardly, sometimes, I believe the figures on the screen there have actually been raised recently. So that is a slight error. But what the gaps analysis has shown is that there is work to be done in relation to maintenance applications with respect to the status of children legislation. It is important to note that the existing law, like most of the other status of children legislative frameworks across the region, has not been applied in every instance to ensure equality of children. Family law commentators addressing this issue have observed that whereas the legislation is routinely applied for succession purposes, it has not brought about equality for children on several other important issues, including child maintenance and custody issues. What this is really saying, and from my own experience in the courts of Grenada, is that the ability for a paternity order to be made is a High Court application at present. And usually, it is usually utilized only when persons are seeking to, for succession rights, when somebody has died and somebody is hoping that they will get succession right by proving that they're a child of that deceased man or person. And so, well, man usually, and to take a paternity application to court and get a paternity order made. But it is hardly ever utilized because one has to go to the High Court for this. And so the children who are born out of wedlock, very often they don't get the same level of attention from the courts, respect from the courts, in the sense that it's more difficult for people to bring these applications, and there are quite a number of hurdles that one has to jump through before one gets a magistrate court awarding maintenance for children who are born out of wedlock. The other heading that we put on the screen earlier was sex offenses law reform. The last one you see on your screen there, I will touch briefly on now. Grenada, adolescents who are 12 years, that's the age of criminal responsibility and older, are subject to criminalization for factually consensual and non-exploitative sex. I've put there absence of a Romeo clause. In other words, when children who are at the age of criminal responsibility, which is 12 years and older, are involved in consensual, and I say consensual in inverted commas, because children at certain ages cannot consent, but you're looking at a perpetrator who is also a victim in a sense, or a child, definitely a child. And the expectation is that the law, or the suggestion is that the law should not be treating them as an adult offender. So that's one of the areas that you will be called upon to discuss in your breakout sessions this afternoon. Then there's the second one. I'm going from the bottom going up. The second one there is that we continue to have laws on our books that say, in fact, this I believe was a recent change, because many years you could not commit rape in relation to having sex with your spouse, even one who refused. And so the law was changed, and now a man can be found guilty of raping his wife. But what is still on the books is that anyone who is found guilty of that offense will only get 14, the maximum penalty is 14 years. Whereas if rape is committed against a non-spouse partner or person, then the maximum penalty is 30 years. The discussion here has to be, well, why should there be a difference in the maximum penalty? This is something for your consideration and for us to hear your views on this matter. Then there is insufficient definition and explanation. This is a highly technical issue, but we still want to hear your thoughts on it, on the issue of consent. The laws at present say that someone will commit rape or commit a sexual offense where there's a lack of consent. And that's all that is said in the law. And so the courts, the high courts, when they are guiding a jury, depends on how the judges see what is a lack of consent. Of course, they will follow precedent and they will follow guidance from previous cases. But there has been a recognition in international circles that if you leave what is a lack of consent, but if you leave that definition without providing some guidance as to what may constitute lack of consent, then you are opening a door for an inconsistent approach that courts will take in relation to dealing with these types of offenses. And you would remember the AG spoke about the rule of law. It has to be transparent, it has to be consistent, it has to be clear, easily understood. And so one of the recommendations we are making is that our laws of Grenada that relates to sex offenses must be tackled again. And we have drafted some suggestions in the face of the bill. And that, again, is something we are hoping that you will provide some feedback on. So these are the gaps that we found under the sex offenses law that currently exist in Grenada. What you see on your screen now is more or less what we just discussed. The last one we haven't touched on, Grenada does not currently have legislation which specifically prohibits sexual harassment. It is merely mentioned in the context of employment where the prohibition is not criminal but administrative. Are we ready? Are we ready in Grenada for us to tackle this, to implement, to pass and enforce legislation that relates to criminalizing sexual harassment in workplace? Are we ready to deal with this? And this is a discussion that you are hopefully going to be engaged on later today. Domestic violence law reform was another category that we saw. There was a need for discussions. There was a need for the goalposts to be moved for us to be able to tackle all the things that we need to tackle. Broadening categories of prescribed applicants, including persons involved in same-sex relationships for protection order. Same-sex relationships, you see that. That's a discussion which I am sure will be an enthusiastic one. We are hoping to hear your views on that, because we have seen some of the other Caribbean countries, though some of them are also under the Spotlight Initiative program, are looking towards expanding the scope of protection, or rather the category of persons who can apply for protection orders. Are we at that point where we can recognize that there are persons who are there living in relationships, sharing relationships, and presently our laws do not provide protection for them under the domestic violence regime? Yes. There's also that concept about with the social media. We have moved on in a world where every bit and aspect of some person's lives are online. In fact, these social media material are now turning up in criminal courts. I have seen a criminal law practitioner in Grenada trying a criminal case involving a sex offense, and he was representing a man who was alleged to have committed a rape against a woman. And the lawyer sought to lead into evidence the Facebook profile of the victim, to indicate what the victim was saying, what the victim was sharing, and to prove what kind of person the victim was. I give you that example because I know it's a startling one, to see that the things we put online are things which can come back at any place in our life at a later point in time. But this is an area where persons are utilizing social media to inflict violence on persons. And we don't have any current legislation which prevent a person from sharing without permission private sexual material in which the victim may be identified. So that's another area we are hoping, and we have recognized that this is a gap, and we are hoping that there will be some movement here, and we are making these recommendations. Family law reform, there are no laws which provide for spousal maintenance in non-marital unions. Yes, and so persons living together and are not married can't turn up and in a court of law and seek maintenance, even though they may be living for many, many, many years and dependent on a man. Rights to property division in non-marital unions. Persons are living together as husband and wife, but not married in the formal sense. And they live, they work together, and the property goes into the name of the man, and for some reason or the other, the parties break up. And our laws on our books do not recognize that the non-married or married partner will be allowed to recover property. There are, of course, I should say as a lawyer, there are opportunities to go to the High Court and seek things like a constructive trust order, but that's a long drawn-out process, and perhaps it is time in Grenada that we recognize that there are persons in our society who live together as husband and wife, and our society's laws should be designed in such a way that we offer them protection, and we remove the inequalities and the discriminations that exist, so that they can have an equal life and a better life, and that the rule of law can prevail, and everything can be based on our basic fundamental human rights. Succession rights of the common law spouse. People live together, husband and wife, without being married, and the man dies, and there are no succession rights currently in our laws that allow that common law spouse, that common law wife, to seek the enforcement of that law to recover property that they shared once as husband and wife in the common law sense. So these are areas that have prevailed in our Caribbean societies and in Grenada, that many of our countries are now moving and tackling and trying to put right. Victim rights law reform. This is an area which is dear to my heart. If only, and I say dear to my heart, only for a simple reason, because I go to court from time to time, and I love advocacy, litigation, and I have seen how, from all standpoints, I have been a defense lawyer, I have been a prosecutor for many years in Grenada, as well as in the Turks and Caicos and in Guyana. And I have been on the bench as a judge, and I have seen how victims are put to the task, how they are further traumatized in court when they sit there to give evidence. I've seen victims being exposed to the most cruel of treatment from some attorneys. I make no apologies for saying that. Of course, the courts are always keen on offering the protection. We passed a law in 2014 in Grenada in relation to protection of vulnerable witnesses, but that law has never yet been put in force. It has not been enforced. We simply need to look at it and enforce it. This is the kind of law that will say, for instance, that if a victim in a sexual case, I use that to drive home the point, if a victim is sitting in the box, a 15-year-old girl or an abused lady, in the normal course of things, unless the judge or the magistrate is sensitive to the issue, where they stop a defendant from cross-examining that person directly and perhaps get a lawyer to come on board, which is not the usual thing to happen in court, the defendant, the alleged perpetrator, is allowed to cross-examine the victims. This is what currently operates in our courts. So you have someone there who is a victim of a sex offense, and if the man is unrepresented, he's standing there in the courtroom and he's looking at that lady, that child, and he's allowed to cross-examine. Of course, the courts in our country are always keen to offer the protection, but I believe that this is a discussion we must have. I believe that we are at a point in time where the laws must offer protection. The laws could possibly say that the defendant should not be allowed to cross-examine the victim directly. There should be an intermediary, yes? And these are some of the things that the law that was passed in 2014 contains, but it has not yet come into force. It is something that requires, an order to bring it into force. But again, we are in that process. We would like to hear your views on whether this is one of those laws which will require some degree of training for law enforcement, the lawyers, the magistrates, the judges, because there are some technical aspects of it which requires that everyone understand the process that is involved in protecting vulnerable witnesses. Currently, we don't have any laws to direct speedy criminal trials. For those of you who are in the audience there, and I recognize many of you, many of you are stakeholders, and you are all very experienced in what happened in the criminal courts. You know that if someone is charged with a serious criminal offense in a sex case, that matter goes to the magistrate's court. It can sometimes last a year, sometimes 2 years, sometimes even more in a preliminary inquiry. And then it goes to the High Court. And there in the High Court, it can last another year, perhaps 2 years, sometimes 3 years. So before a matter comes to finality and ends in the trial courts, sometimes 5 years can pass. Victims grow up in court, and that is something which we need to address. It is something that we need to have a discussion on. It is something that we have drafted some amendments, some suggestions, which we hope that will become policy and eventually become law, but we're hoping to have your views on this. We're saying that these criminal trials that relate to sex offenses, these matters, there should be a legislated time frame within which they must come into the court and they must commence as trials and they must end in court. And we say that that period should be perhaps maximum of a year. Preliminary inquiry should be completed within 6 months. In fact, number 3, bullet point 3 there, laws that make paper committals mandatory, that is one that we're hoping that will apply to all sex-related matters where the magistrate, the defendant has no right to object to a paper committal. What that means is that instead of an oral committal PI in the magistrate's court, one would move straight into looking at the papers. The magistrate looks at the statements the police collects or has collected, and the magistrate makes a determination that there is sufficient evidence for this person to be tried for a criminal offense and sends the paper immediately to the High Court judge. And so the High Court judge, after a person is charged with a sex crime, this is the recommendation we are making, that after a person is charged with a sex crime and all the statements are collected, within the space of about 3 to 6 months, the matter is in the High Court. So this 1 year, 2 year period that where a matter languishes in the magistrate's court no longer exists. We're saying that we are a society in Grenada, in the Caribbean. I've seen a number of other countries where there is a large number of sex cases before the court, that this is an area that requires direct attention. We need to tackle this. Yes, so victim rights law reform is a very important area, if only to ensure that the institutional mechanisms that seek to enforce all these law reforms, because we can pass many, many laws. As the AG has said, it is our ability to make those laws work. And sometimes in trying to get laws to work, we have to also pass laws, as you see on your screen there on that slide. We have to make these processes effective and efficient as well. One of the areas we have tackled is to look at how we can have a roadmap in creating a family code. This has been attempted in Grenada before, but this is an area where we feel that we can use the current laws, we can use the current administrative structure, and we can create a separate family code in Grenada, where it comes under the umbrella of one administrative mechanism, is one of the suggestions we are presently discussing, because this has not been finalized as a proper recommendation yet. But we have sort of hopefully suggested that an approach can be that there is one administrative structure, and which is guided by the philosophy that family-related matters involving sex offenses, involving family-related matters and children should have a different governing philosophy. It should not have that same conflicted courtroom atmosphere that is normally associated with courts. We should move away from when you turn up in a magistrate's court in Grenada now, perhaps this might be the ideal, you are turning up in that very same court where people are being tried for criminal offenses, and you have children there. Luckily, our courts for many years now have been separating family-related matters from other matters. And so there's a child day, children day in most of the courts, where children come to court and they are not mixed up with other persons who are alleged to commit criminal offenses. That movement is what we need to cement into one cohesive and comprehensive family code structure for Grenada. And this is a discussion that we are having at present. There's one of the recommendations made, it relates to a sex offenders registry. This is on the victims' rights law reform. In Grenada, there is no legislation establishing a sexual offenders registry, despite the high prevalence of sexual offenses recorded, especially against children. Is it time, is the question I've posed, for us to have that sex offenders registry? There is a bill already drafted, in fact, it's been drafted for several years now, that requires a discussion. Are we ready? Are we at that stage where we can put this in place? So my task as the advisor to the Spotlight Pillar 1 component has been to look at all of these gaps in our laws, examine them against the background of a rights-based approach, and come up with recommendations. We have taken the initiative. I think on last year, December, we drafted a number of bills. Now, again, I must emphasize, there are many ways to have consultation. One is to speak, to have these discussions with perhaps only white papers or position papers. Two is to take the initiative and start to draft and then have the discussions. Either of those versions or either of those approaches does not mean that what we have put on paper is set in stone. In fact, quite the contrary. These are all informative stages at the moment. These are all simply suggestions, recommendations being made, and they are there for you, in a sense, to see our crystallized thoughts, for you to look at these documents and to actually see it on paper, what it is we are saying are the gaps, what it is we are saying are some of the recommendations going forward. We hope that you would examine each and every one of these bills that you have been given. I met with a number of organizations last month, I believe it was, in a similar, well, not quite similar, we didn't have so many persons involved, but in a consultation session. And I was promised by a number of those groups that they would present to me written responses in relation to their own views. Today's session does not replace that wish list of mine that you provide me. I'm smiling that you provide me with those written responses, but I'm hoping as well that quite a lot of the work that or responses that you will give will come out in these sessions that are going to be held this afternoon. So we have also presented some primary bills related to primary legislation, that is the Criminal Code Amendment that relates to the consent, the Employment Amendment Bill, some sexual harassment issues covered. Right. So we have also domestic violence reform. We have suggested, we have given you a draft, an amendment bill that will also be the subject of discussions this afternoon. And it will cover the gaps that I have discussed earlier about extending the scope of protection for victims of domestic violence. Are we ready for that? And how far do we go? We've spoken about the National Sex Offenders Registry and the consent in the Criminal Procedure Code. Well, the Criminal Procedure Code amendments relating to the timelines for criminal trials, criminal procedure preliminary inquiries related to mandatory paper committals, removing the need for the oral committal, protection of witness commencement order, that relates to the law that was passed in 2014 that is not yet in force. And so we have drafted something there, hoping that all will be on board in terms of that this needs to come into force. We need to have a law that is working and that protects victims and witnesses in trials, in courtroom situation, because we all recognize that there are many victims out there. Sometimes they do not report, or if they report and matters become court cases, sometimes these court cases fall apart with the passage of time when people decide, you know what, I cannot turn up in court again and be further traumatized. So we have recognized, in fact, this is not a new recognition, this has been an old recognition, that we need to ensure that trials and courtroom situations do not further traumatize persons who seek to have their rights protected, who seek the remedy of the law. And so our courtrooms need these processes to be put in place. We need this clarity. We need to move on. Yes. Again, these are a list of legislations that we have drafted as bills, and we have touched on these earlier in relation to succession rights, rights for maintenance of non-married parties, and you see them there. So let me stop my share. So I have taken 9 minutes past the time I was allotted, but I'm hoping that the message I'm seeking to send is one which is clearly carried across, that we have done some of the work. I could not do all of the work. I have sought to capture the gaps that are there, and we have sought to draft what we believe to be some suggested legislation. I use that word clearly and pointedly to make the point that this is in a formative stage. We hope that these discussions zoomed in, focused in on the bills that we have drafted, on the issues which are raised, because I believe the facilitators for these afternoon breakout sessions will not necessarily look at the actual bills, but they will pull out the issues, they will extract the issues, the gaps, and that will hopefully frame the discussions on the way forward. And we are hoping that whatever comes out of these discussions will help us to decide how much more work I need to do in relation to the bills. Remember, this is simply one component of the Spotlight Initiative and the work that it is doing in Grenada. We are on law reform, and we are hoping and thinking that what will come out of these sessions will help us to bring this component to a conclusion. I thank you very much. Ms. Redhead, I turn back the microphone back to you.
Thank you very much, Queen's Counsel, for that very comprehensive overview of our current legal framework and identifying some of the deficiencies. What you have underscored for us is the value of a rights-based approach, and you have certainly challenged us today to examine our own personal belief system and how it lines up with international best practice. So we certainly have our work cut out for us today. We have about 15 minutes. We will ask QC to entertain some questions from the audience. I believe there's a microphone. You can indicate by show of hands if you would like to ask a question based on the presentation this morning. So we do have a question. We do have a question for you, Mr. Ramdani. So ensure the microphone is on so that we can hear.
Good morning. Can you hear me?
Mr. Ramdani, can you hear?
Can you hear?
Yes, I can hear. Thank you.
Good morning, Mr. Ramdani. I'm a retired teacher. I know nothing about law, but I'm being an English person as well. I thought common law relationships in England, if you were together for 7 years, you were allowed to claim something. For example, I know someone who her husband or a partner died in a common law relationship, and she was really virtually kicked out of her house with her children, and she had to go find somewhere else to live in Grenada. So I was wondering if you're based on English law, Grenadian law is based on English law, I believe, is there anything that you could think about that might bring this thing forward, that if you've been together for 7 years minimum, you might be allowed, if your spouse or your partner died, you'd be allowed the property or something from the household when the partner had died.
Thank you for your question.
Yes. Thank you for that question. Many years ago in the Caribbean, I believe one of the first cases reported in the WIRs, as the West Indian law reports, speaks of a case called Hack and Rahiman coming out of Guyana, in which the issue of property rights related to a non-married partner arose. And the courts, for the first time in Guyana, pulled into the courtroom principles of constructive trust, where they said that if the lady had helped to build the steps of the house, cooked the food for such a long time, took care of the children, it did not matter that she did not earn a single cent in her lifetime. It was sufficient that she had contributed in a manner that was meaningful. And the law courts of Guyana decided that she was entitled to share in the property. It is one of the first reported decisions in the region, and most, if not all, of the region under the English-speaking common law have moved in the direction of assessing whether non-married partners are entitled to share in the property belonging legally to the other spouse, common law spouse. England, I know, has a Family Dependence and Provision Act. Those words are in the name of the act. I'm not sure if they go that exact way. Family Dependence and Provisions Act, or Dependence Provision Act. Guyana has a similar one, and I believe some other countries have one. What it really means is that if you can show you're a dependent and someone has died, and you can demonstrate a dependency, whether or not you're a spouse, but as someone who has been getting financial benefit from a person during his lifetime, then you are entitled to share to the extent of that dependency. I haven't examined all of English law, so I can't speak directly to what this 7-year period may mean in the context of English law, but what I have done is to examine the Grenada law. And we don't have any specific legislation that says if you have lived for a certain number of years with someone and they pass away, that you're entitled to anything. In fact, this is what we are hoping, that these discussions will get us to that point. And the recommendation is that we are hoping that that will become written law in Grenada. Some of the other Caribbean countries have gone that way. Our neighbor in Trinidad is one of those countries which actually has a law, an express written law in place that says if persons are living together for a period of 5 years in a bona fide relationship, and one of them is deceased, the other one is entitled to share property of that person. Of course, the courts have a certain mechanisms in place to determine how much they should be getting. I see somebody else have a hand up. I hope that answers that part of the question.
I'm just going to ask you, when you put your hand up, to just identify yourself by name and who you represent today.
Good morning. My name is Decima Williams, and I'm representing the Grenada Education and Development Program, Grenada. I want to thank all the organizers for the session and to thank the QC Ramdani for his summary, the gap analysis, which is quite valuable. And I think you're right that there are so many achievements. Particularly proud I am of the CEDAW passage here in Grenada, as well as the Convention on the Rights of the Child. My question to you is, to what extent do you think there is an adequate interaction between law and education? In other words, legal education seems to me one of the gaps. It's a legal gap, it's an educational gap. And perhaps that is the basis needed now, both for knowledge about what we have and for advocacy to strengthen the required legal reforms that have been contemplated. And I'm very pleased to see the number of drafts, legal drafts, that are on the table so people could actually have a place to start. So that's my concern. I'd like your thoughts on it. That there seems to me a fundamental gap in education and people knowing about the law and the power of the law as well as its gaps. What are your comments on that? Thank you.
Is it Ms. Williams? Yes.
Yes, it's Decima Williams.
Thank you very much for that question. You are an educator, I gather, from your initial introduction. And your presence today, hopefully, continues the link between us creating policy, drafting laws, and passing laws to the education of our nation's children. I do not pretend to have an answer to your question. What I hope to contribute is to say this, that this is a process that we all of the stakeholders need to play their own little part in. I have seen Grenada as one of those countries that has a vibrant debating component in the school programs. I see them debating as young parliamentarians. I see them debating at other levels as well. And they take on in those sessions many of the topical issues that arise in our country. I have always advocated that more and more of the country's topical issues need to be brought into the classrooms. But this has to be done in a structured way to ensure that our children receive only what they should receive at that level at the very least, because our school's curriculum must be structured and guided. So I am sure some of this is being broadcast live and possibly will be on on the social platforms afterwards and carried by our news media. And our teachers are listening, hopefully. And the discussions will continue in the homes. The education of our nation's children is not only a school event, but is a home event as well. I have been an educator part of my life. I, in fact, started as a young teacher at the age of 16. I continue to lecture now at the University of Guyana, dealing with prosecuting. But I do believe it requires all of us to be able to share the knowledge and the information. And sometimes when we go back to our own homes, to indicate to our children who are of sufficient age to understand those things that we wish them to share in. So Miss Williams, you are better placed to answer the question than I have done. And I'm hoping that you will help in the process going forward.
Thank you, Queen's Counsel. Do we have any other questions? We have time to entertain.
Hi. Hello.
Yes, we can hear you. Spector?
Okay. Yes. Good morning, and thanks for the invitation.
Can you just say your name and introduce yourself?
Yes.
Thanks.
My name is Claudette Pitt, and I'm a member of the St. Patrick's Environmental and Community Tourism Organization. I listened to Mr. Ramdani, and sometimes at moments during his presentation, I felt very sad that being involved in the Organization of Women 43 years ago, when laws and policies were enacted to ensure that Grenadian women was on a platform of social, economic, and political movement towards progress of the integration in the society of Grenada. I'm pleased to see that there is so many. So I go back. I noticed elimination of all forms of discrimination against women, 1979, nothing else was said, and then near to it, I ratified 1990. What really is the situation legally now? What is holding up? After we've been at a place where women in Grenada, where this was discussed in households with our children and the wider society, that we had come to a point where we recognized that there was serious discrimination against women and children. What has happened since then to now? Because it would seem as though this large gap, for me, it is saying, well, women did not want this anymore. And I'm sure that's not true. What really, Mr. Ramdani, held up all of these legislative procedures that has prevented all these legal bills that have been drafted and sitting there? I don't want to sit here today and believe that it's simply because women don't know, children don't know. I agree with Desmond. There needs to be much more education, and I agree with her on that. But to me, there is a serious policy gap here. Where is the commitment to that policy from since then to now? I know people's laws were thrown out, but people's law number 3, I think it was one of the first laws that eliminated all forms of discrimination against women in 1979. People were taken to court, I believe. Why up to today that we are still wondering? Why we are still wondering as women, what has happened to us? I don't know if he could answer that.
Queen's Counsel.
But I sit here and feel very, a little bit sad that after all of this, we are back. Thank you very much.
Thank you, Ms. Pitt. Queen's Counsel, I'm not sure if you have
I-
an answer to that question.
I do not think that I can answer, but I can contribute to the discussion. When you ask why we haven't done X for so long, I suspect that question can be asked 20 years from now, and it can be asked 40 years from now, and it would have been able to ask it 50 years in the past. It is a question that is melded, welded to our souls. As we grow and society evolves, we continue to have a changing perception of the needs or the things that needs to be done to make life better for all of us. And after World War II, when the nations came together, the United Declarations of Human Rights was drafted, and there was an identification of fundamental rights. But that was not the first time fundamental rights were recognized. Fundamental were recognized with the original Bill of Rights from way centuries ago. And so sometimes we need to have reaffirmation. We need to recommit ourselves. And so 20 years or 40 years in the past, Ms. Pitt, when there would have been that commitment for us to get it right, every year thereafter or every anniversary thereafter, we needed to sometimes revisit and to recommit. I would ask that you view this, that we are in this great opportunity of reaffirming that we need to have an examination done of what are the basic fundamental rights that we need to see respected. We need to examine where all of the inequalities exist. What are all of the forms of violence exist? And this is an audit of sorts. We're conducting an audit of Grenadian life right now. We're conducting an audit of the laws of Grenada, how they fit in protecting fundamental rights, how they fit in eliminating and eradicating violence against women and girls. How do our laws fit? Do they meet the muster? Do they pass the test? And we say to you that you are one of those fighters in this battle going forward. I'm hoping to motivate myself, yes, that we can recognize that we have work to do. We have work to do, Mrs. Pitt. I don't know how else to tell you. We have work to do.
Thank you very much, Queen's Counsel. And we are going to shatter the Caribbean stereotype. We are on time, and we are going to keep on time today. It is now 11 o'clock. At this juncture, we'll take a short break. I want everyone to return to this room at 11:20 to start our panel discussion. And I'm going to ask you, because some interviews will be conducted during the break, to remain outside until you are asked to return to the room. Thank you.
Well, good morning, Grenada. For UNICEF, we are the facilitators of Pillar 1 of the Grenada Spotlight Program, which deals with policies and legislation for ending violence against women and girls. There've been a lot of technical assistance being rendered under that pillar, which looked at Grenada's landscape, legislative landscape. It saw that you're doing some things well, but you need to do some things even better. There are definitely some gaps. And so the importance of today is we don't just want to have, and governments don't just want to have laws which sit on books that are not implemented. We want people to know and to discuss what are the evils and what needs to be remedied. So the importance is that a wide cross-section of people get to better understand what that legal gap analysis has said and to weigh in on it, to share their views.
Thank you. And Ms. Telesford, would you like to add from your perspective? Right. Good morning, and thank you for the opportunity. From the perspective of the Ministry of Legal Affairs, who, in collaboration with UNICEF, is responsible for the work that is being done under Pillar 1, Law and Policy Reform. Now, today is critically important to the work that is being done through the Ministry of Legal Affairs, because the consultative process is absolutely important to informing the legislative reform which is going to take place under that pillar. So as you would have seen that we had our legal consultant, Mr. Ramdani, on board with us today. The discussions which will come out of today's event, particularly the sessions this afternoon, will help to inform the process, will help to add considerations and bolster the recommendations which will come out of the Pillar 1 work thus far. So today's event is critically important in that regard.
Very good. And as you mentioned the outcome, let's delve a little bit deeper into that. From the perspective of UNICEF again, what would be the best possible outcomes from today's event? In an ideal world, is that everyone here buys into the ideals of where we would like to get to. From this morning's discussion, whether it was the address by the Attorney General, UNICEF's own perspectives, the Grenada National Organization of Women, the legal consultant, it underscored that we all should be looking at the fulfillment of human rights. And sometimes, though, that desire sometimes conflicts with some very personal beliefs. If everybody was on the same page of us moving in the same direction, for us, that would be the ultimate outcome for today. Because there are some things that have been in place for a very long time. Sometimes change is difficult. But together, we can educate ourselves, and we hopefully would move in the same direction.
Yes, ideally from the legal perspective, what we would like to see is that all the recommendations that have been made with regard to legislative reform are taken on board, and the political will eventually be to have these recommendations, these draft new legislation be passed and be brought into force. And at the end of the day, as we said, we don't live in an ideal world, but ideally we want to see the total eradication of violence against women and girls in Grenada, Carriacou, and Petit Martinique.
Okay, thank you. And finally, if all goes well, and in the ideal world, all the plans come to fruition, what impact will that have on the lives of women and girls in Grenada?
For us, I think living a life free of violence would be a significant step forward for all of our society, where all of us can live really in peace and harmony. It would mean for children ending legalized violence in the form of corporal punishment. It would mean that there's no distinction between children born in and out of wedlock. It would mean security within relationships, the predominant form of the family in the Caribbean are unions other than marriage. But still in many states, and the legal analysis showed that here in Grenada, those protections are not necessarily afforded to persons within those unions. So if everything came to fruition, I think that Grenada will see strides socially and economically.
And I want to endorse everything that Heather has just said, and just to add that it would mean that by the year 2030, the government would have achieved one of its sustainable goals of gender equality. And that is the ultimate goal in all of this. Thank you.
So thank you both, Ms. Stewart and Mr. Telesford, for your valuable information and discussion here. We appreciate it. And we wish Grenada all the best in pursuing law reform to act for violence against women and girls. Thank you very much.
Yes, good dog. Watch it. Watch me. Watch it. You see? Yeah, don't talk.
So we are joined here by Ms. Shirley Herbert, who is the chairperson and president of GNOW. Ms. Herbert, thank you for joining us. How important is today's event for women and girls in Grenada?
Well, I think it's, thank you for having me. It is indeed a good event. The fact that it's happening today, I would say never too late. There are laws, as we would have heard earlier today, that they're archaic and they need to have some reform. While the existing laws have these gaps that they mentioned, and they were very specific, I'm saying that the experts like Mr. Ramdani and so pointed us to specific areas in terms of common law, children born out of wedlock, in terms of the misses or the gaps in those laws. We need to have reform as we evolve and as we develop. We need to get in line to ensure that there's adequate protection for the children and for the family as a whole.
Okay, and what, from GNOW perspective, would be the best outcomes from today's event? What would you like to accomplish at the end of today's event?
Well, we are hoping at the end of the day's event, we have a roadmap, ideas, suggestions that we can take forward in terms of influencing that change, in terms of the advocacy, in terms of what needs to be done so that ultimately the family, children who are most likely, they are a vulnerable group, women and children will be protected.
And elaborate a bit about that, because in the ideal world, if everything goes right, tell us a little bit of how that would positively impact the lives of the women and girls that you interact with as GNOW.
We interact with a lot of women, a lot of children on a daily basis, at home, in our workspaces, on the street, in the school, and it's important that people feel comforted and know that their rights are protected first as individuals. And a lot of this starts at home. So once the changes are made, once persons become aware of the laws, one's person, and that is important too in terms of educating the public. And I say everyone needs to know how they can be protected. They need to know what their rights are, so that in the event there's an issue, there will be some form of redress.
Right. So from your perspective, today's event is a critical first step in what could be a permanent change in the lives of many of our marginalized women and girls.
I hope so. Something really needs to be done, especially in our small island state, for starters. Given that our statistics are alarming, we are affected when children are affected. We are impacted as well when our women and our girls could hardly, or let's say,
Recording in
to go
progress.
out, because what may very well happen. We need to have safer home, safer spaces, a safer community, and ultimately a safer Grenada first, and then that could be extended throughout the region and by extension the wider world. Because once you're able to impact people and impact people directly, then that the same leverage can be used and meted out in the wider public.
Ms. Herbert, thank you very much, and we thank GNOW for the work that it has been doing through the years in advocating for the protection of women and girls. Thank you so much.
I thank you.
their way back in. Okay. I'm going to invite everyone to start making their way back in. Thank you. Huh? Okay. And I hope that during the break, everybody remembered to fill out their registration form. A representative from GNOW will be passing around to collect your completed registration form. Will you get all this thing today, registration form? So please try and complete your registration form. The rep from GNOW is collecting registration forms. Yes, yes. Oh, maybe it's the registration. Yes, the registration. Okay, okay. Okay. Yeah, that makes sense.
Just that they need to see the screen. That's one of the close that one a little bit so that.
Oh, you mean, but what, Jackie, can you see? Yeah, I can see. Yeah, it should be okay. The only thing, so for example, Anandi would not see Jackie's presentation when she's sitting there. That's the only downside.
They will not what?
So Anandi would not see your presentation and you would not see Anandi's presentation when you're, yeah.
That's true. But we'll
Sorry?
hear it.
You'll hear it? Okay. Okay. Thank you, everyone. Welcome back. I know we are eager to get into the next segment. Something I omitted to do, And I'm going to ask everyone to stand and observe a moment of silence for two champions. One is Angela, and the last name, sorry? Angela Julian and Judy Williams. Angela was employed with the Grenada National Organization of Women. Judy Williams, I'm sure this is a name familiar to most of you, was the General Secretary of the Grenada Community Development Agency. Legal Aid is a project of the Grenada. And also, she was a member, I'm informed that she was a former member of the GNOW. So it is only fitting, given what we are doing here today, to observe a moment of silence in recognition of these two stalwarts. Thank you. Now, as promised, we have our panel discussion, and our panelists comprise three experts. They will discuss key policy and legislative issues for transforming the lives of women and girls in Grenada. We have Mrs. Jackie Seeley Burke, Mrs. Anande Trotman Joseph, and Ms. Chrissy Worm, who will be joining us virtually. She's the Permanent Secretary in the Ministry of Social Development, Housing, and Community Empowerment. Mrs. Seeley Burke, a former director of the Legal Aid and Counseling Clinic, so my former boss, and the person who actually hired me at Legal Aid and Counseling Clinic. So it is indeed a pleasure to introduce her here today. She has over 25 years of practical experience as a lawyer and a consultant. She has local, regional, and international experience, having worked throughout the OECS, the wider Caribbean, and North America. She has produced a wealth of reports for international and regional agencies, including UNICEF, UN Women, the World Bank, the OECS Commission, and the Commonwealth Secretariat. Child rights feature very centrally in Mrs. Seeley Burke's social justice work, resulting in not only extensive research, but also the development of legal and policy frameworks for the advancement of children and families in almost all of the Caribbean countries. So it gives me great pleasure to introduce to you today Mrs. Jacqueline Seeley Burke, who is going to present to us on law reform from a children's rights perspective. Mrs. Seeley Burke.
Thank you so much, Jasmine, and a very, very pleasant good morning still to everyone, and I welcome the opportunity, I truly do, to present briefly on the topic of law reform from a child rights perspective. When approached to present on this topic, I said, you know, I'm going to have to think long and hard about how best can we talk about this topic in a meaningful way within the short 15 minutes or so that has been allotted to each of us. And I thought it best to address it in a more contextual way, setting the stage for our more substantive discussion this afternoon, because those of you who are in the child rights group we're really going to be probing these issues in a far more drilled down kind of way. So when you juxtapose the term law reform with child rights, we could either speak about the importance of law reform to shaping or defining a child rights perspective, or we could approach it the other way and focus more so on how a child rights perspective influences law reform. You see, the starting point would be different, but the discussion will probably take us in the same direction, because law reform and our evolving social norms and perspectives are cyclical. And what do I mean by that? It's right there now. Well, if you think about it, evolving social values, attitudes, they help shape the law. And the law, in turn, helps shape social values. So you see the cycle there? Let me use an example. Next slide. There was a time when we had what we call bastardy laws. Y'all remember that awful, awful term? Yes, bastardy laws. Where the law said that children born out of wedlock were not recognized as children really deserving of rights, and certainly not the same rights as those held by children within a marriage. But then our social conscience, our social sensibilities around this issue evolved, and people started questioning, how could this be fair? Especially in a social context where over 70% of our children in the region are born within non-marital unions. The public became increasingly dissatisfied with the current status of the law, and they threw their weight behind the view that the law should treat all children equally. This building of public sentiment on the issue was able to withstand even the objections of certain religious segments of the society who opposed the law reform on the grounds, they said, that if we recognized children of those unions, then it was giving implicit recognition to the relationships from which these children were born. And Lord forbid, how could we allow that? That view was pushed back and paved the way for the passage of status of children legislation, what some of us refer to as a child is a child legislation, yes? But similarly, if you look on the other side of that slide, there are times when social values or the public's conduct on an issue is influenced by law reform, where the state, in its legitimate law-making capacity, passes a law that says, this, people, is the direction we are going in on this issue. The law is passed, and we see attitudes, we see behavior, we see values shift accordingly. And a potent example of that, it's a simple example, but it's so potent, and it's one that I witnessed for myself because I came to Grenada back in about 2000. So I saw, and I think the seatbelt laws got passed 2001, 2002, so it was soon after I came back into the region and came here to Grenada. A seatbelt law was passed in Grenada, and it was vigorously enforced. No one in Grenada cared much about seatbelts, right? Hardly anyone wore them, right? When I came here in 2000, people were not wearing seatbelts. But the state decided in their wisdom that it was important for the protection of people using our roadways. And within 6 months, this society, this Grenadian society, was transformed into one that people did not go into the front seat of a vehicle without being buckled up. Am I telling a lie? I saw Mr. Helliger, those who know Mr. Helliger, who was driving at 80 years old. I stood in front Siboney Chambers once on H.A. Blaze Street there. And I saw Mr. Helliger, who would never in his however many years of driving a vehicle, right? Once that seatbelt law was passed and was enforced, you couldn't go from here to there without being ticketed, yes? I saw Mr. Helliger get in and click his seatbelt. So the law is a powerful tool for shaping our values on issues in the same way that our values as people can significantly influence the trajectory of the law. So it is a cycle. Next slide. So when we speak of law reform and a child rights perspective, we need to be mindful of both those forces within that cycle. The growing recognition that children have rights and are not just there to be seen and not heard is increasingly gaining due acknowledgement across the world, across our region, and yes, even in Grenada. We as a public now, today, much more so than 30, 40 years ago, see children as capable of having rights. And that's why we rejected the idea that a child born out of wedlock should be discriminated against. It's why we now speak in terms of children having the right to an education. You hear people saying that. As well as the right to live free of sexual abuse and exploitation. And most people will defend those rights with all their might. And so this is where we see social attitudes helping to push the development of the law in certain directions. We have experienced so many positive, developments in the law for children in Grenada because of that growing, slow, but growing acceptance of children's rights. And that's wonderful. That's wonderful. However, there are times, and I'm still on this slide, there are times where law reform is proposed, and there may be no social consensus on the issue. Where some people are for it, others are against it. In those instances, the law is sometimes based as well on international human rights and child rights standards that we as a nation have agreed to abide by. Children's rights, like human rights, are not there at people's convenience to be honored when it suits us and disregarded when it doesn't. Human rights protect us. They protect us from being discriminated against. They give us the right to free speech, the right to gather to protest, the right to a fair trial. Children's rights are a subset of human rights because children are human too. And they too deserve to have their rights respected and protected. In that regard, the global and our regional community has signed on to international human rights and child rights commitments. And the one most noted for children is the Convention on the Rights of the Child, ratified by Grenada in 1990. In these circumstances, the law helps to shape or transform the way that we see the rights of children. It helps inform the perspective that we bring to how the law should handle situations involving children. So, let me give you some examples again. Where children could have once received the death penalty in some countries, the laws in most of those countries, have now changed because international child rights law has taken a position on that issue. And as a global community, we have signed agreements to abide by it. Another example, when some countries said, it is our custom, and we hear people talking about custom, right? They said, it is our custom to perform female genital mutilation on our girls. And those countries says, we don't consider that child abuse. The international community reminded those countries, right? And reminded them in no uncertain terms that they were part of a global community that respects the rights of children and that those trump their local customs and should therefore effect change in their national laws. With time, the views on executing children for even the most heinous crimes and the butchering of children's bodies in the name of custom have evolved. Even in those countries where it was once accepted, in fact embraced, people now have totally different views on these issues. This is the power of the law. Next slide. Grenada's proposed law reform agenda is full of issues relevant to children and their rights. There are a range of issues, including child maintenance, we heard this morning, protection of children from marriage, corporal punishment, the right to sexual and reproductive health services. As we discuss these issues later today in our groups, we need to keep in mind that just painted, what I just went through with you, that just painted backdrop of child rights, law reform, and their impact on each other in our minds. Let's keep that in mind as we reflect on the following issues. 1, how should we deal with the current law that allows children as young as 16 to marry with parental consent, as opposed to setting a minimum age of 18 for marriage across the board? 2, how should we address the issue of children being able to access sex and reproductive health services with or without parental consent, especially when they are sexually active or contemplating being sexually active and will not want to involve their parents? What age should they be able to access that information, that advice, those services? 3, how should we deal with the issue of corporal punishment? Not just in the schools, but also in the home. That's a controversial one, right? The national law, as it stands right now, permits it, but it is not consistent with our international child rights commitments. 4thly, how do we address child maintenance reform in a present legal context that still systemically discriminates against children born out of wedlock, because the system has created this hierarchy of child support, where those who are not married are largely reliant on the magistrate's court, and those who are married will ordinarily access the higher court, the high court, with different treatment of these cases and different outcomes. We did a project, UN Women, together with Legal Aid and Counseling Clinic many years ago called Share the Care, where we looked at that disparity in the child support outcomes in the courts. And where child maintenance orders are sometimes worth not much more than the paper that they are written on, because the enforcement provisions within the law are so weak and ineffective. So I want to end, if we go to the next slide, I want to end by saying that these, some of those ones that I just mentioned, and many other issues will require our thought, our attention, and our reflective deliberation. That is the purpose of our gathering. And so I hope that as we do that today, this afternoon, that we can do so always mindful, if it can come back up, always mindful of both the value of law reform as well as the power of a child rights perspective. Thank you so, so very much.
Thank you very much. Another round of applause, please. Thank you, Mrs. Seeley Burke, for giving us some vivid, concrete examples of the symbiotic relationship between the law and our social attitudes. And you have also reminded us of our pledged responsibility in a global context to recognize, respect, and protect the rights of children. I know you have questions, but I'm going to ask you to please save your questions for the end of our panel discussion. Write them down so you don't forget. And without further ado, I will invite to the podium Lady Anande Trotman-Joseph, attorney at law. She's the founding partner of the law firm of Chapman and Trotman in Georgetown, Guyana, former Solicitor General of Grenada, presently the managing partner of the firm of Joseph and Joseph in St. George's, and she's admitted to the bars of Guyana, Grenada, Trinidad and Tobago, and the British Virgin Islands. Lady Joseph has served, participated in, and led diverse national and regional organizations. She's presently the chairperson of Grenada's Integrity Commission. She's a past chairperson and present vice chairperson of the Commonwealth Association of Integrity Commissions and Anti-Corruption Bodies, and is the chairperson of Grenada's Customs Appeal Commission. She chaired the Grenada National Coalition on the Rights of the Child, the Adoption Board, the Preparatory Committee to End Child Sexual Abuse, served as governance chair and PRO of Grenada National Organization of Women, a past president of the Grenada Bar Association, and was a member of the UN Women's Civil Society Caribbean Advisory Group. She has represented Grenada's child rights and women's organizations at the United Nations in Geneva, Switzerland. Her publications include a co-authored OAS Manual for Women in Politics, Getting a Campaign Right, the European Journal of Law Reform, article on constitutional review of entrenched provisions favorable to vulnerable groups of society, and hallmark reports on the rule of law and human rights issues. Most recently, she produced Grenada's Beijing 20 National Review, a national strategy to end gender-based violence, the national position on gender equality for constitution reform, and co-authored a multi-country study on juvenile justice for UNICEF. I know the accomplishment that she's most proud of is that she is the proud grandmother of a beautiful little girl, Satori. So I welcome to the podium Lady Anande Trotman-Joseph, and she will present on law reform through a gender equality lens.
Thank you very much, Madam Chair. And indeed, you have brought me to the podium with a big smile on my face. But let me just say good morning to my colleagues, of course, at the head table, and to all of you sisters, mainly sisters, gathered here. And of course, we have some male allies, we presume, through the facilitating by the gentleman, Leon from Charles Consultancy, very gender friendly, obviously, and of course, the folks, the guys who are on the technical team. So this morning I have been asked to share with you, and I say share with you and discuss the topic for this panel discussion on law reform through a gender equality lens. I do bring to this discussion, as you would have heard when our mistress of ceremony shared my bio, I was hoping she would shorten it a bit because it made me realize how busy I have been, but I continue to be busy because I am an investment of other women and men so that I can be here today to speak as an attorney about law reform, but also speak to you as a woman, a mother, a wife, a grandmother. In other words, when I'm coming to discuss gender equality, I do so as a lived experience. But before I go forward to get deeper into this topic, I think it is only right that I share with you all some definitions of what this nice topic is about. And we do have some students, and I'm very happy about that, because even as I'm talking about paying myself and my experience forward, they are here to learn and to take our discussions forward into their own homes, schools, and communities. So I will start first with a definition about gender. Now, I am sure when I say gender, most of us think women. But the truth is, that's not what gender means. Gender is quite different from the sex of a person. And traditionally, in binary terms, that means male or female, boy or girl, man or woman. However, gender is a social, and I'm going to use a word here, students especially, a social construct or construction, especially for those of you who know a little bit about sociology and so on. This means, as an explanation, that gender, as it relates to men and women, male and female, is what society expects it to be. So, in sharing about this definition, I think that I can best give an example, which is a European history example. I don't know how many of you here would have studied European history. I did it when I did A-levels, the equivalent of CAPE now. But when you open those older European history books, you would see pictures of the royalty, the noblemen in high heels. I don't know if anyone has ever seen that. And that is where the term well-heeled comes from. So we women now are walking around in high heels. I made sure I put on a little heel to get a little height. But we were not the original wearers of these heels. For those of you who know a little bit about our colonizer, the United Kingdom, you would know that in Scotland, part of the United Kingdom, the men wear skirts, and they're called kilts. Yes? And I had a great opportunity through this same work, gender work, to get to Samoa. And out there in the Pacific Islands, the men wear, guess what? Skirts longer than the ones in Scotland. Likewise, today we see that women wear trousers, and more recently, I am seeing right here in St. George's, women who are even dressing like men and wearing Clark's boots and so on and so on. So, I'm sure that you are getting to understand that gender does not mean only women. So when we were invited to discuss gender, we don't see the men coming because they figure gender means women. But it's about the relationships between male and female and everyone in our society. But we'll get to that a little later today. But right from the very beginning, our own understandings of gender would have been limited by our assignments. If we were a girl, they would have put us in pink. If we were a boy, they put us in blue. As you started to grow, girls, you were given a doll, and the boys were given a gun. A little later, he buys the car, drinks the Guinness, and she poses to sell those cars in very sexualized advertisements. We at GNOW, we know we have mounted many campaigns, not very recently, and we heard Sister Pitt earlier. What has happened? It's on us, sisters, all. So, it is obvious then that for the purpose of our discussion and for our advocacy leaving here, that we understand that the principle of gender equality must be used as an advocacy campaign and platform and a tool to push back and climb past, in some cases, male-dominated or controlled spaces, and very often we say male chauvinism. Traditionally, of course, men have controlled our parliaments, boardrooms, places of employment, and so on. In Grenada, there's somewhat of a shift in this regard, but we will discuss that perhaps a little later on. So this gender equality that we're talking about is really, and following on our Sister Jackie's explanations, it's really a human rights concept coming all the way out of the Universal Declaration of Human Rights, which was an agreement between states following the atrocities of World War II. And Article 1 of the Universal Declaration of Human Rights says, and I quote, "All humans are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood." And this is the principle of equality and non-discrimination that has actually been adopted into Grenada's own constitution. So if you're interested in reading more, please look at your secular Bible to know what your rights are. Lens, I want to quickly help us to understand these lens that we're speaking about, the lens that we are looking through to see gender equality. I am wearing glasses, some of us are, and you who do would know that when you go to the optician, they'll be changing different lenses and asking you, which one is best? Which one are you seeing through? And eventually you get the right fit, you're prescribed with your lenses, and out you go with new frames, seeing through new lens. So it is this kind of example of lens that we are being asked to look at gender equality, having now understood what gender means, not man or woman, but the way we in society treat with our sexuality and who does what, who wears what, who wants to project as what, and who, and so on and so on. So let us put on gender lens so that we can understand going forward today what it is that we really need to understand. And what we really need to understand is that we need to respect one another, irrespective of who we are. We need to respect all Grenadians, all persons, wherever you're from. That is what we mean by these gender equality lens. We need to make sure that in our discussions and our thinking, going back to our homes, to our churches and so on, that we really do, in the biblical sense, love one another in a way that is not discriminating, looking down, excluding, socially excluding anyone in our society. So law reform, it may sound like two very simple words, but what does law reform really mean? As a lawyer, I'm sure I'm taking the words law reform for granted because I know what it means. And as you heard, I did spend some time in the Attorney General's chambers as a Solicitor General. But in reality, so that you understand what you're being asked to listen for and to go forward for the rest of this afternoon's exercises in particular, it means that, as we have heard earlier, there needs to be a review of the existing laws, and in this case, that are being focused on by the Spotlight Project and the Spotlight Initiative. That is why we are here. Now, most of us know that when laws are passed, nobody asks us anything. We just turn on our TVs in the night and we hear, or radios at the midday, and we hear that Parliament has passed this law or that law. So how come this particular area of law reviewing is allowing us to gather and discuss? That is because it is law reform, and in particular, it is law reform around issues that go to the very fabric of our existence as Grenadian and Caribbean people. So, that is what this is about. It is called socio-legal in a bigger term, fancier sounding name. So before the parliamentarians go back to Parliament, they want to know what we think. And why do they want to know what we think based on this kind of reform? Because, let's face it, if they go to Parliament and pass laws that are so controversial because it affects the rights of all of us in our bedrooms, in our homes, in our schools, when we walk down the road and we are the subject of street harassment, sisters, you all know that term, it's evolving, it's unwanted in our workplaces, that every man thinks that every woman wants to be with him, for example. Sisters, you know what I'm speaking about? All right. But mark you, I said unwanted. Doesn't mean that you wouldn't find a mate or a date in your workplace or in a public space, but it is only when it is unwanted. But I'm saying all of this to say that if our lawmakers rush ahead and pass this kind of legislation without coming to we the people, then they run the risk. Guess what? Next election, they may face a very huge backlash. And that is why you would find that for these kinds of topics that we're discussing today, around child rights, gender equality, the rights of women, common law, relationships, and so on, you find that the law reform goes deeper than the average subject area. Next slide, please. So, what we are discussing today really is our reality here in Grenada. We must honestly together examine our cultural and social realities and norms, which have bearing on informing our understanding about why problems of gender-based violence and intimate partner violence remain, and I'm going to use a big word, unabated. In other words, it's not going away. No matter how much we talk about it, no matter how much money we throw at it, no matter how many consultations like this we have been having, we still seem to have these problems. Then now we're hearing that there are gaps in the laws. Why is it, and we heard it through a commentator, why is it that our laws are not protecting women and children? Why are our women and children in common law relationships not getting the kind of legal protection that they are entitled to? These are the problems and issues under our spotlight here today. Our culture. Yes, you know, a lot of us like to talk about our culture, our folk songs, our calypsos, our soca, and all the representatives that we have, and all the cultural ambassadors that we're seeing and hearing. And of course, as we know, Carnival is coming up, and we're hearing it all, and we're dancing and so on. Yes, culture is very often a blind spot to enabling gender inequality. What do I mean? We all know that most of us, even if you don't like calypso or you don't like folk music, when you hear those drums, you hear those beats, you will tap a leg, snap a finger. Many of us, we dance, yes, we whine, we tap out the rhythms of our Caribbean music. We hear the smutty calypsos and we let it go through sometimes one ear and come out the others. We hear the dance hall music. Many of these lyrics, born across the beats, encourage sexual harassment, aggressive sexual behaviors against women and girls, and even violence. Yet we embrace blindly these subcultures through the rap and dance hall that disrespect women, calling them whores and bitches. And yes, we are dancing sometimes, encouraging gun salutes, bigging up gunmen, bigging up the herb, but we dance on without censorship. And then all of us want to criminalize these very behaviors and criminalize our gullible youth. So let us think about these things when we're thinking gender equality. It is okay for us as women, students, mothers, grandmothers, say, well, that's not us. But if we do nothing for our sons and daughters, then we are all responsible for what happens with the fabric of our society. Unconscious bias is another challenge to women and gender equality, because very often, as I was just alluding to, we women ourselves unconsciously embrace the music, the culture, the laws, the belief systems, the ways that sometimes our own religious beliefs are expressed in a way to exclude us from even serving God and praising God as we should. But the biggest challenge that we experience to women's and girls' equality would be in our own homes. Yes, in our homes. And why is this? Because our home is away from where everybody can see what's happening. So it is not when you're walking past the guys playing cricket or football in the pasture and they're calling at you and you're rebuffing them. It's about a place where no one except those who live there know what's going on. So gender-based violence and discriminations are becoming so normalized in our reality that no one is holding accountability. Instead, sometimes we women say, based on how somebody that we know would dress, she look for that when we hear something has happened to her. She wearing the skirt too short, she wearing the pom-pom shorts, and so on. She look for that. But did the nuns and so many others who have been abused in so many areas of the world, the women in their hijabs with their gongs right down to their feet, they too get raped, irrespective of the length of their skirts. So we know it is something deeper. So our discussion today has to be around gender equality and these issues. And I have to share with you, yes, I'm sharing as a woman my own lived experiences as a woman. I'm seeing you nodding in agreement and understanding. But there's a flip side to this gender inequality, especially with respect to gender-based violence and intimate partner violence. I'm flagging it because we cannot speak equality without looking at both sides of this situation. When I was doing the consultancy that you would have heard about to end gender-based violence in Grenada, I went to all of the parishes across Grenada, Carriacou, and Petite Martinique, and I heard a story from a particular senior police officer who was sharing that in a particular parish, they were getting lots of situations where men were coming forward. They were being battered at home by their wives or partners, but they were too ashamed to admit it. So they were staying outside of the stations and sending somebody to call the police officer to share what they were experiencing and trying to get some kind of support and counseling. Through this work, I also learned at another forum like this that child sexual abuse, though proportionately known to be against our girl children, may, and I say may, perhaps be even more perpetuated against our boy children. I was so surprised. We have now come to a place where we get our little girls to talk, to report, and people are reporting. So the village is encircling the girl child, but it is not encircling the boy child. And this information got to the St. George's University Public Health Study through self-reporting. So they would just pass out these questionnaires to the boys and just ask them to fill them up without saying their name, perhaps saying their age. And this was the kind of feedback, and that was several years ago. And therefore, we must recognize these underneath topics in our society. These are what we call taboos. And in the case of the boys growing into men, this is what I would call in Grenadian parlance, underneath taboo. Because they're not talking, they're just beating out, they're just acting out, just disrespecting their sisters and the women in the society. And sometimes we can't understand. So this is what I mean by we're throwing this money, we're throwing the laws, we're throwing the efforts. But until we get deep down to understand why this inequality, why this abuse continues, then we are not solving the problem. No matter how many laws we pass, no matter how many gaps we ensure that we identify. So, having said all of this, I am coming towards the conclusion that I will ask each of us to take away from my sharing this morning into this afternoon. And when we continue to consult among each other, I want us to keep it real. I want us to be accountable as girls, as women. Where we can be joined by men, we have to tell them that this is how we feel. We have to ask them how they feel about these issues. Remember, the men too have peer pressure through the music, through our expectations of them to be macho, to be man, and so on and so on. And very often, women are their own worst enemies. There's a lot of work, inside work we have to do, sisters, because we ourselves, through embracing these unconscious biases that I shared about, we fail because we have been socialized this way to value everyone else. The males, the sons, we give and we give and give, but no one is taking the time to tell women that they must value themselves. They must invest in their own self-worth and self-esteem. Through my work with GNCRC, when we were working with HIV and youth and other STDs and stigmas around that, it was crystallized that we need to teach our young women especially to negotiate relationships and their roles in relationships. Because if they don't understand that, they will end up living lives that represent toxic femininity. Likewise, we have to tell our men, our boys, that they need to respect and value the contributions of their mothers, their sisters in the home. They need to value the love, the very free love that would be shared by especially their moms in the home and in the society, so that they don't live lives that characterize what is called toxic masculinity. So, this means that we have to now look towards what we call culture shifting. And in our consultations later today, yes, we must understand that through looking at the laws and the recommendations to the laws where there are gaps, that it is our state's obligation by accepting, signing on to the Convention Against the Rights of the Child and the Convention for Elimination Against Discrimination Against Women, that requires our states to make sure that the laws and the institutions protect everyone from discrimination, especially the most vulnerable in our societies. And that is called the protective scope of the law. However, this needs to be done progressively. And I shared already why our parliamentarians can't just rush in always and pass laws if the society is not keeping up. So this is what law reform means for these social issues. We must take the laws off the shelves where they are gathering cobwebs, but we must make them our tools so that we can protect all of us and change our lived realities, especially with respect to the issues of abuse, inequality, and discriminations in terms of looking at all this through gender equality lens. Take off your glasses, those of you who have them. Now put them back on. Let us reframe, rethink, reimagine Grenada that is free of gender-based violence, where everyone, irrespective of whether we're male, female, whether we are male who want to wear high heels, like the royalty, or skirts, and we're seeing some modern rappers in skirts recently, or the guys from Scotland or Samoa or the Pacific Islands, whatever we imagine that we are, let us respect each other. Let us not discriminate against each other. And may this be the spirit of the consultations as we continue today. And thank you.
Thank you, Lady Joseph, for defining and clarifying for us what gender means, not only in a local context, but we got to travel to Scotland, Samoa, and back for rationalizing for us the importance of putting on gender equality lens to inform our conversation and discussion later this afternoon. So we are going to move right in to introduce our next presenter. Let me just check with our technical team to ensure that Ms. Worm is standing by. Our next presenter Mrs. Chrissy Worm-Charles, the Permanent Secretary in the Ministry of Social Development. We heard from her earlier. Housing and Community Empowerment, a UE graduate. She has a Master's of Social Work, a BSc in Psychology, and is a proud alumnus of St. Joseph Convent, St. George, and a past teacher of the Boca Secondary School, an educator, academic, author, clinical social worker, and agent for change. Her entire career has been grounded in the belief that all persons are inherently equal. She serves the truth and serves it with humility, integrity, pride, and purpose. Ladies and gentlemen, Mrs. Chrissy Worm-Charles.
Thank you so much, Madam Chair. I'm hoping that everyone is hearing me. And my task is very simple today, right? Though it may be simple, but it takes an entire village really to push the agenda forward, to ensure that we buttress against some of the law reforms and that we continue what we do as a ministry. So I hail from the Ministry of Social Development, and our Ministry of Social Development is one of the leading human service organizations in Grenada, tasked with the responsibility of being the vanguard of persons who are vulnerable, right? And we take this job very seriously. I'm very proud to be working with some of the most dedicated duty bearers that have ever walked, right? And also to working with our key stakeholders, those of us who are in the NGOs and even the CSOs, who continue to work together to ensure that everybody's dreams are realized and that we all join our forces, against the scourge that has been affecting our country, the violence against our women, girls, and boys, right? And I don't want to exclude our men as well. So it is a vexing situation, and we really need to do what's necessary to ensure that we are together and that we are on one page, right? So it is with this that I start my presentation today. And we are going to be looking at policy initiative to buttress the law reform. We've heard a lot today. We've heard about some of the changes that will be occurring. We've heard about the breakout groups that we are going to be engaging, where we're going to be getting discussions so that we now can make that meaningful contributions towards our law reform that is affecting our people as they transact in environments that may not be very conducive for their growth. Now, so position paper looked at the child maintenance and the status of the child reform. And I'm happy to note that the Maintenance Act, right, will be under review, and it will be part of our legislative agenda for 2022. And that is why today's discussion is going to be so important. The issue at hand here is that we speak about experiences. We've seen people navigate through traumatic exposures to so many different and difficult challenges that they encounter on a daily basis. So what is going to happen? How do we figure out, or how do we experience social justice, right? Which is inherently important for each and every one of us. How do we exercise social justice, right? And it is so critical that, yes, we point out what needs to be done, but most importantly, what are the protective factors out there that will buffer the effect and even cushion the blows that some of our vulnerable population will be facing or have faced, right? And so the legislative agenda, I'm so very pleased that it's on the agenda in terms of the review of the Maintenance Act, right? And we noticed too that, there are so many gaps present in the Maintenance Act, and it can be considered very archaic. And permit me to just read a little extraction of this paper one. It discriminates against children born out of wedlock, referred to in the act as illegitimate, right? So we're seeing acts now still being utilized with the word illegitimacy, being used to describe the child who is born out of wedlock, right? A child is a child is a child. There's no hierarchy. when we are looking at our children. Each one of us was a child before, some of us maybe, because I'm seeing some CC students in our midst. But the fact of the matter is, equal and equitable access should be for all, irrespective of your birth circumstance, right? So the fact is that it's still in the law in terms of legitimacy. And it prohibits the court from making maintenance orders in respect of spouses who have committed adultery, right? So right away, we see a disproportion of access for children. And we're saying that that should not be. And that is why it's important for us to review and give our feedback in relation to our Maintenance Act, right? And when we look at the change in our situation, in our economic situation, we would definitely understand that the amount of monies that are allotted for children in relation to maintenance is too low, right? Now, children are a blessing, right? They are an inheritance to us, and they are the bearers of our future, right? So they are pleasant surprises in many instances, but it comes with responsibilities, right? And so parents have a responsibility to ensure that their children are well taken care of, right? And that is a major concern. And we've seen over the years, and I know many of our duty bearers who are there when we go up St. John Streets or when we pass any of our court or judicial system, we would see very long lines, women and as well as men too as well, but mostly women who are standing there, to ensure that their children get what they deserve. And that is not correct, right? Children, they are brought into this world, and as such, they have to be supported. It is the inherent right to be supported. And so our legislation should support it, and that is why it's so very good to see that it's part of our legislative agenda 2022, right? So as we move along, recommendation for sexual offenses reform, we note that now is included in our legislative agenda for 2022. Already there's a draft sex offenders bill, and also upscaling the existing support systems. Earlier on, you heard me speak about buffering the impact upon some of the negative experiences of our people, right? And so it is very critical for us to have support systems that are strong and creating platforms of access and continuous professional development amongst our staff and the people who give the service, right? So we have to ensure that we work within a rights-based perspective. We have to translate what's on paper into reality. And it is so critical for us as social workers, because I still see myself as a social worker in many ways, right? Because that is where I started off. And it's very critical for us to have continuous professional development. The ministry is very committed to that. And we would have had different types of training over the years. And I know Spotlight would have invested significantly into many of our training activities. And we have people with different areas of specialization, right, to impact positive changes, right? And to ensure that the intervention strategies are spot on. So we're seeing an upscale in our support systems. We're seeing that some of our safety net, they are becoming robust, and we are slowly moving away, right? And I think it should be more rapid, though, from the welfare approach of human development into a more supportive approach to human development. And so we have transformed certain names from welfare into development, moving along this continuum from one stage to the next, where people can experience proper self-actualization. And so our systems, we are aware that we have gaps within our systems, but we continuously refine it. And one of the things that we have learned over the years is that most of the services that we are giving now is empirically based, by us, for us. And we are very inclusive in our approach as we look at people who, are victims of violence. And let me say this, right? I'm speaking here as a woman. I'm speaking here too as well as a Grenadian. Right? Our society needs to be mended, right? And we have the power within us to make those transformative activities into our reality. All right, our children should not be transacting in an environment that does not do well for the overall well-being, right? And it's simple steps that we have to take, just being each other's keeper, right? And ensuring that we respect people and that we treat them with the proper rights that they have earned and they have deserved. Why? Because they are human beings, no separation, right? And our principles would be able to guide us along that line. So I want to say this, that, you know, when the law is being reformed, we also have to look at how do we garner again some of the spillover effects. And some of those ways are supportive systems. And already our ministry would have moved from one space to the other. So we have increased the amount of people who are working in different areas. So we have more outreach offices, we have more officers assigned to the various district offices, and we have expanded our probation unit, we have expanded some of our human resources. And sadly, it is still not enough based on some of the burgeoning issues that we are seeing here and the fallout reflected in our social system. So it's a continuous process and we are committed to it. And together with our social partners and together with everybody in Grenada, we continue to ensure that people who engage in our systems, you know, get the best results that they possibly can. And where they experience those gaps, we have to strengthen our mechanisms to ensure that it is minimized as best as we can. Now, it is important to note that a domestic violence reform, I think this would be a very topical issue, right? So one of the disclaimers to be put out there is that, you know, the Ministry of Social Development is inclusive and non-discriminatory in its approach, right? We have signed on to so many different treaties and so forth that encourages us, you know, to be inclusive in our approach and supports people who are faced with domestic violence. And note the word people, because that's how we see our clients, as people, right? And the services include social services, housing, gender and family affairs, which includes gender-based violence unit, social safety nets, and other social protection mechanisms put in place to garner the impact upon domestic violence. And domestic violence really is a vexing situation, right? And sad to say that it is so very prevalent within our society, our communities, our families, and on an individual basis, right? Violence in a lot of ways have been interlaced within our very repertoire, right? And it is time that we do something about it. You know, I know we have placed actions, right, over the years, but, you know, we have to ensure that it is sustainable actions, right? So that we can reduce the occurrence of violence, right, or eradicate it, right? We have a lot of our social partners who continue to fight that fight, right? And it is our inherent right to live in a peaceful society. And so we continuously build on the systems, right? Strengthen our memorandum of understanding with various different ministries, taking on a whole of government approach. Even it is reflected in our medium-term agenda and our national sustainable development plan, right? So that, you know, all efforts are geared towards working with children, working with families who may have been disjointed or have been discriminated against or have experienced some level of violence, right? So I want us to understand that this is not an idealistic space that we operate in on. There are gaps, but I want to stress here, we have committed duty bearers working within the Ministry of Social Development and other key stakeholders who are committed to the task, right, of ending violence against our girls, our boys, right, and our families. Now, we're looking at law reform, changing that narrative, right? Adherence to the normative frameworks such as CEDAW, Bellem, DEPARA. These frameworks regulate our policies and programmatic approaches for persons seeking our services, whether they are in marital and non-marital unions, all right, most significantly. And the operative word here, persons, people, right? So our approach, as I said, is inclusive and is non-discriminatory. Most recently, we would have had a hybrid Geneva Treaty Body initiative for assessing the status of countries, reporting obligations, CDAO, and the CRC was done in March 2022, regulating what we would have done, and we have to be answerable to these committees, right? In terms of some of our policies and the necessary actions that we would have taken in relation to ending violence against our families. And as we speak again, our social protection system. So you'll hear these words being echoed consistently through this presentation in terms of social protection, because that is what it boils down to. So our social protection systems continue to cater for the needs of our vulnerable populace through the safety net program and other key interventions, right? So already some of our social safety net has been bolstered, and we have expanded some of our safety net horizontally as well as vertically, so that people can gain access, right? And one of the things that some of our officers would have experienced during our COVID lockdown is the silent pandemic, the shadow pandemic, the increase in domestic violence, right? Because partners were locked in with each other, and it was so very difficult. It was a difficult period, right? And so we had to do something, and we had to expand our reach to try our best to reach the needs of our populace as best as we can, all right? And not everyone was reached, but we tried to reach as much as we could have. And due to the investments from many of our key stakeholders, some of the people's experiences and realities were made better, right? And this brings me here to the last slide. Position 5, recommendations of victims' rights reforms, included in the Legislative Agenda 2022, joint approach with Ministry of Legal Affairs, and we have a draft victims' rights policy in progress and a draft sex offenders registry bill. Now, our victims' rights are, it's in progress, but that is really critical, right? So we are giving power to our victims, ensuring that they are able to be their own agent. And once they engage in any systems that they are not satisfied with, they have the right and they have that space to speak out, right? So we are sharing that power. Although the power belongs to everyone, but everyone should be aware that they have access and they have their own power to report, right? Incidences where they are not comfortable with any fact of interventions, right? So we are not working in isolation, and we are moving forward, right? So it's not necessarily an oppressive environment in that regard where victims may go, report their cases, feel like if they are not heard, right? So we believe in the process, we believe in human worth and dignity, and we believe in equitable and equal access for all, right? And so we would have done significant trainings, right, with all our key stakeholders to ensure that our standard operating procedures, even as we speak now, our ministry is working continuously with our developmental partners and even with partners within to ensure that our multi-sectoral teams in the different divisions are strengthened so that engagement by our clients would be more lucrative for them and they would have positive responses, right? So it's my presentation in a nutshell was just positioning our government, right, in the view or in the light of social development, because we have different key stakeholders who perform social protection activities, right? So it's a position where our ministry stands in the fight and the plight to ending violence against women. And I really want to commend again the UN system and the European Union for continuing to invest in our country as we all work towards eradicating, gender-based violence, right? It is a real situation, it's a vexing situation, but I believe that if we continue to work together, we can see change. We can be agents of and by change, and I think it's very critical for us to understand that. And I'm very, very happy to see in the room today different cadres of people, right? Even the students too as well, who would be able to get those types of experience so that when they go into the society to practice, right, that they would be very confident that they would have contributed significantly to the reforms that, that is so completely necessary for our country at this point in time. So I want to thank you very much for listening, and I want to hand over to the Master of Ceremony, Ms. Redhead. And I want to say that, you know, as we continue as a ministry to buffer the effects, we believe in continuous professional development, and we continue to do effective targeting and promoting full range of rights for domestic victims, survivors that guarantee fairness, equality, and respect for human dignity. So I thank you very much, and we look forward to serving you.